Hi, I'm Jim Covington. Today is January 12, 2017. I'd like to welcome you to this week's issue of ISBA Statehouse Review. The 100th General Assembly was just sworn in yesterday, and they have begun introducing bills from the legislature, which they'll begin taking up in committee action later this month and early in February. I'd like to talk to you about 5 bills that have just been introduced. No substantive action has been taken on them. The first bill is Senate Bill 65, amending the Title Insurance Act. By Senator Mike Hastings of Frankfort, and it requires all title insurance policies for the sale and purchase of residential real estate transactions to be issued through the same policy issuing entity unless otherwise agreed to by the parties. And that would take effect on January 1, 2018 if enacted. The next bill is Senate Bill 67, also introduced by Senator Hastings, that establishes the Collaborative Process Act for family law cases only. And it creates this process act for those using the family law cases on or after effective date of this bill. People are using the collaborative process in family law bills as we speak, but there's no guidelines or regulation of it, and this statute purports to do that. And it probably will be accompanied by a proposed Supreme Court rule later, and that was just introduced. The third bill by Senator Hastings amends the Illinois Marriage and Dissolution of Marriage Act. It's Senate Bill 69, and it is it's what I call a reconciliation bill. In the last 2 to 3 years, the General Assembly has passed and the governor signed a number of just simply huge bills affecting marriage, paternity, artificial reproduction, child support. This bill sort of tries to reconcile all those together to make sure they all work together well, and that's just been introduced. That would have a July 1, 2017 effective date if enacted. The next bill amends the Illinois Administrative Procedure Act. It's House Bill 301, introduced by Representative David Olson of Downers Grove. And it provides if an agency decides to hold a public hearing, it must post on its internet website certain information to provide the public with the notice of the proposed rulemaking. If the agency decides not to initiate a public hearing, it must post the requirements to request a public hearing along with information on the proposed rulemaking on its internet site. And the final bill I'd like to talk to you about is about the setting of bail. It's House Bill 314, introduced by Representative Art Turner of Chicago. And it allows the sheriff to apply for an increase or reduction in the amount of bail, or to alter the conditions of the bail, or grant bail if it's been previously revoked or denied. If monetary bail has been set and the defendant has been unable to post it, the defendant must present a verified application setting forth in detail any new information not known at the time of the initial decision or obtainable at the time of the setting of bail, or the previous revocation or denial of bail proceedings. If the court grants bail and it has been previously revoked or denied, or changes the amount of bail, the court must state on the record of the proceedings the findings of facts and conclusion of law upon which the order is based. That's also been introduced. Thank you for listening. We'll talk to you next week.